This is Emmy Award-winning Full Disclosure with Leslie Dutton, bringing you the news behind the news.
It's so unusual to sue a court because that's really what you're doing. It's such an interesting lawsuit to file a lawsuit against a court.
Full Disclosure took the court to court. We sued the presiding judges of the Los Angeles Superior Court for denying us access to record a dramatic sequence for our full-length production entitled The Cost of Courage, The Story of Richard I. Fine. Our friends at Judicial Watch understood this as an important First Amendment case. Director of Litigation Paul Orfanedes represented us in court.
You were seeking access to a courtroom. You wanted to use the courtroom after hours to film segments for a documentary you were producing.
The sequence we needed to reenact was the moving and powerful speech of former U.S. Prosecutor Richard Fine. Mr. Fine confronted Judge Yafee in the courtroom, basically indicting him for bribery because of all the Superior Court judges are accepting illegal payments from Los Angeles County. In response to this affront, the judge demanded the arrest of Mr. Fine and had a squadron of sheriff's deputies take him into custody for an indeterminate term of coercive solitary confinement. Mr. Fine spent 18 months in jail.
The Superior Court has a practice of allowing people to make use of their courtrooms after hours for any number of reasons. And in this particular instance, CNN had been allowed to come in and make use of the courtroom for the very same reason you wanted to film a segment about an important case that had taken place in that courtroom. The Superior Court denied your request multiple times without explanation. And we pointed out, you let CNN in, how come you didn't let Leslie Dutton in? They never responded. They never did. So we filed a lawsuit alleging a violation of your First Amendment rights, including viewpoint discrimination.
What he means by viewpoint discrimination was the fact that Full Disclosure has long been highlighting the claims of Mr. Fine, documenting the fact that the judges of the Superior Court were indeed taking double payments, enjoying double benefits that were clearly in violation of state law. After his arrest, Full Disclosure produced dozens of programs that brought attention to the fact that they were illegally imprisoning a man who had never been convicted of a crime. The judges apparently didn't want to provide their facility to anyone who made them look like hypocrites.
You had really highlighted what occurred to him, what happened to him in the course of his whistleblowing. And we were alleging viewpoint discrimination. We filed this lawsuit. It was dismissed by the trial court in a sort of perfunctory manner. In my view, the trial court didn't seem to really understand what our claim was. We appealed, and the appellate court agreed with us that we had properly pled everything we need to plead to state a claim for viewpoint discrimination, which is a First Amendment issue.
So the appellate court agreed with us. But what is the significance of that ruling?
That means we live to fight another day, is what it really means. The case is going to go back to the trial court now, and we're going to have to fight some more about whether or not you were discriminated against on the basis of your First Amendment, protected expression.
He explained how the appellate court came up with their ruling.
When a court considers a motion to dismiss, and that was what was before the trial court. What the court is doing is looking at all the allegations raised in the complaint, and it's asking the questions. If all of these allegations are true, does this give rise to a claim for a First Amendment violation? And the answer is either yes or no. The trial court said no, it did not. We go back to the appellate court, up to the appellate court. The appellate court asks that same question, and it doesn't defer to what the trial court ruled. It's called de novo review. It looks at the same question afresh. And in this circumstance, the appellate court said, yes, we had stated a claim for viewpoint discrimination, so it has to go back to the trial court.
So does that mean we're starting all over again? Apparently, yes.
Unless the Superior Court, the defendant, changes its mind and decides it's not worth fighting anymore for a half hour worth of time in a courtroom, which is all you asked for.
Yeah.
You know,
Yeah, it's,
I don't know how much they've spent in attorney's fees on this to date, but you know, it has to have been a lot of money, and I'm not really sure what the point is. You know, I really don't understand what they're trying to achieve by saying CNN can come in, other groups can come in, but Leslie Dutton can't come in. That seems to be a waste of taxpayer resources.
well, it's not their money, is it? We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, do you think that the presiding judges of the Los Angeles Superior Court have the right to deny access to the public courtroom to media that has been critical of the court? Yes or no? Do you think that the judges of the Los Angeles Superior Court were more concerned about avoiding discussion about their illegal double benefits? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you.